In a recent opinion, the Second Circuit weighed in on George Santos's copyright lawsuit against Jimmy Kimmel. At issue were Cameo videos Santos made after his expulsion from Congress, videos that ended up on Jimmy Kimmel Live as part of a reoccurring comedy bit. Very funny one, by the way. The district court dismissed the case on fair use grounds, but Santos appealed. The Second Circuit has now spoken, and the result is not good news for the former congressman. I'm Scott Hervey, a partner with the law firm of Weintraub Tobin, and I'm joined today by frequent briefing contributor and my partner, Tara Sattler. We are going to break down the Second Circuit's decision in Santos versus Jimmy Kimmel on today's installment of the briefing. Tara, welcome back.
Hi, Scott. Nice to be here as always.
Yeah. So Jimmy Kimmel's been in the news lately, but we're not going to talk about what he's been in the news about lately. We're going to talk about this other thing that also made the news, and that's the lawsuit that George Santos filed against Jimmy Kimmel and ABC. Let's start with the background. So Santos, who was expelled from Congress, turned to Cameo to make some money by selling personalized video messages. Jimmy Kimmel and his team saw a comedic opportunity. They created fake Cameo accounts and ordered 14 videos from Santos with deliberately absurd prompts. Kimmel then aired some of these clips on his show in a segment called Will Santos Say It?
Right. And in these segments, Kimmel wasn't just replaying the videos. He framed them as kind of a satirical game show, highlighting Santos's willingness to say just about anything for money. Of course, Santos didn't really find this funny, so he sued Kimmel, ABC, and Disney for copyright infringement, plus some state law claims like breach of contract and fraudulent inducement.
Right. The key copyright issue was whether Kimmel's use of the videos was protected by the fair use doctrine. That case landed in the Southern District of New York, where Judge Denise Cote dismissed it at the pleading stage, so very early in the lawsuit stage.
Yeah, that is early. So let's walk through that decision. The district court acknowledged that Santos, as the talent under the Cameo's terms of service, held the copyright in the video, but the defendants argued fair use.
Exactly. Under the four-factor fair use test, dealing with the first factor, the purpose and character of the use, the court found Kimmel's use was transformative. The videos were not used as a heartfelt greeting, but as political satire and commentary on Santos's willingness to say almost anything for money. The court emphasized this is a form of criticism, something the Supreme Court in Warhol versus Goldsmith recognized as core fair use. The second factor, the nature of the copyrighted work. The videos had some creative elements, but the court said this factor played a minor role. The third fair use factor, the amount and substantiality of the work used. Kimmel used the full videos, but the court said that was reasonable. The point of this segment was that Santos actually said ridiculous things. Showing less would undermine the political criticism. And then the fourth factor, the effect on the market that the use has. Santos argued that airing the videos undermined Cameo as a platform, but the court just rejected that. There was no evidence that Kimmel's use harmed the actual market for Santos's Cameo sales. I'm very curious what those are anyways, but okay.
Yeah, I agree. I agree. So the court also brushed aside Santos's argument that Kimmel's deceptive method using fake accounts mattered. Fair use, the court said, is an objective inquiry into the use itself, not the motives behind it.
Right. So the district court dismissed the copyright claims as barred by fair use and tossed the state law claims as either preempted by the Copyright Act or just insufficiently pled.
So after that, Santos appealed, and the Second Circuit heard arguments in March of this year, 2025, issuing its opinion recently in September. And the court affirmed across the board.
Right. So on fair use, the Second Circuit agreed that the first factor, the purpose and character of the use, strongly favored Kimmel. Santos tried to argue that the videos were not transformative because Kimmel instigated their creation, but the court rejected that, writing, whether a secondary use is transformative turns on what a reasonable observer thinks, not the subjective intent of the copyright holder or of that secondary user.
And the court pointed out that by Santos's own admission, the original Cameo videos conveyed feelings of hope, strength, perseverance, encouragement, positivity. And by contrast, Kimmel used them to lampoon Santos's willingness to say absurd things and say it for money. That difference, the court said, actually really strongly supports a finding of fair use.
Yeah. Santos also argued that Kimmel acted in bad faith by misrepresenting who he was when ordering the videos. Yeah, I'm sure Santos would have, agreed to do this if Jimmy Kimmel said, "Oh, I'm Jimmy Kimmel. Would you like to do these videos?" Maybe if he offered him enough money, he would. Who knows? Anyways, going back to the point here, the Second Circuit dismissed that, saying the complaint itself showed that the defendants weren't trying to replace Santos's commercial market, but instead were motivated by sarcastic criticism and commentary.
And as for market harm, the Second Circuit stressed that the analysis looks at substitution, not reputational damage. The court wrote, "We ask not whether the second work would damage the market for the first by, for example, devaluing it through parody or criticism, but whether it usurps the market for the first by offering a competing substitute." And here the court said no one was going to license Santos's cameos to criticize him. So there really was no market harm.
Right. That's a great analysis, implementing the kind of shift in this fourth factor that we saw in the Warhol case. All right. So after affirming dismissal of the copyright claims, the court turned to the state law claims. Santos had brought a breach of contract claim, breach of implied contract, and fraudulent inducement.
So the breach of contract claim was based on Cameo's terms of service, but Santos wasn't a party to those terms. The Second Circuit said under Illinois law, there's a strong presumption against conferring benefits to non-contracting third parties, and Santos couldn't get around that.
The implied contract claim failed because Santos didn't plead any actual terms or meeting of the minds between Santos and Jimmy Kimmel or ABC. And the fraudulent inducement claim failed because, as the court put it, Santos failed to allege he suffered any actual out-of-pocket loss as the victim of the alleged fraud.
Yeah, so the Second Cert affirmed in full. The copyright claims were barred by fair use, and the state law claims all that failed as a matter of law.
So let's talk about some of the takeaways from this case, Tara.
Yeah, I think there's a few big takeaways. First, even in this post-Warhol world, criticism and commentary remain strong bases for fair use. Courts are willing to protect satirical or critical uses, especially when the target is a public figure.
Right. Second, deceptive conduct in obtaining material doesn't necessarily doom a fair use defense. As long as the ultimate use is transformative and critical, courts may overlook questionable tactics. However, I think we need to think about that in light of the recent Claude AI loss in the Ninth Circuit, or sorry, the California's District Court, right, where Claude and Anthropic had essentially stole over 500,000 books for the purpose of training the Claude AI, and the court said that this, even though the use potentially was transformative, the training of the AI, actually Judge Alsop called it spectacularly transformative. It was the theft of the books that the court found to be actionable. So I don't know. It's interesting. Maybe deceptive conduct in obtaining material. I think we need the question the nature of the deceptiveness. So maybe stealing is not okay, but being deceptive might be all right. Maybe that's how we parse this. I don't know. We think we need to think about that a little bit more. That might be an interesting briefing topic, looking at these two elements. Anyways, sorry, I go off on a tangent. Let's go ahead.
Well, I was wondering about that too. It definitely seems like there's a fine line, and I think the nature of the deceptiveness, but probably also the impact of what the deceptiveness has, fair use or not. I mean, I think these cases are a little bit different in that way too, but I was thinking about that. We're gonna have to make that.
I mean, maybe one is like the severity of the deceptiveness, because piracy is, I mean, that is a form of deceptiveness, but it's separately actionable.
Concealing your identity, I
Yeah,
think, is because ultimately Santos, if he didn't like the absurd prompts, he wouldn't have to do them regardless of who made the request.
right. It's yeah, that's an interesting juxtaposition, and I think one, if you're dealing with this situation, I think you need to really think carefully about how what the deceptive conduct was.
Yeah. Okay, so back to our takeaways. I think a third takeaway is that creators can't bootstrap themselves into contracts that they never signed. Santos wasn't a party to the Cameo user agreement, so he couldn't enforce it. And that's a useful reminder in the creator economy.
Yeah, that is interesting, right? That's interesting. I think that these terms of service are really binary, right? They're not multi-party. They're between the user and the platform. They're not between multiple users and the platform. And a user, unless the terms of service specifically say that they're a third-party beneficiary, they can't like shoehorn their way in. That's real interesting. That's real interesting. All right. Tara, thanks for joining us today. Always great to have your insights. And thank you to our listeners for joining us today on the briefing. If you found this episode helpful or interesting, please take a moment to subscribe, like, and share it with your network. We'd also love to hear from you. Please leave us a comment or review and let us know what topics you would like us to cover in the future. I'm Scott Hervey. See you next time on the briefing.